Hello friends, in the series on the income tax cases, today we will discuss a very important issue. The issue is that if the department issues some show cause notice to the assessee and tries to bring the assessee into the circle of assessee in default on some basis, like in this case when the show cause notice was issued, it was alleged that the assessee is a defaulter of TDS under section 194C, but when the orders were passed by alleging that the assessee has not deducted the TDS under section 194I. The whole basis of treating the assessee in default has been changed. So the question before the court in this present case was that whether in these type of cases, whether the matter should be remanded back to the assessing officer for rectifying the mistake of the department, or whether it is a curable defect. The name of the case is DLF Homes, Panchkula Private Limited versus Joint Commissioner of Income Tax, and this case has been reported in 459 ITR at page number 723, and the matter has been decided by Honorable Delhi High Court, and the date of the judgment is 24th March 2023. In the present case, 4 show cause notices were issued to the assessee for treating assessee in default for the non-deduction of TDS under section 194C on the payment of external development charges to the Haryana Urban Development Authority. When the assessee received these notices, the assessee challenged these notices on the ground that the external development charge is a statutory obligation. It was the plea of the assessee that external development charges is one of the conditions for obtaining the licenses, and the assessee further pleaded that it is a payment which is in fact in the form of a charge to the state government. So the TDS under section 194C is not applicable because there is no contractual payments. When the assessing officer received these submissions of the assessee and passed the order under section 201, the assessing officer didn't mention in the orders that section 194C is not applicable to the assessee, but changed the whole basis of treating the assessee in default and said that the assessee is liable to deduct the TDS under section 194I by treating the external development charges as rent, and created a huge demand of rupees 12 crore rupees. The assessee filed the writ petition against these orders. When the matter were before the Delhi High Court in the writ petitions, the department said that and admitted that the assessing officer has by mistake applied section 194I, and the department contended that the section 194I is not applicable, and at the same time pleaded that the matter should be remanded back again to the AO to correct this error, because revenue was of the opinion that it is a curable defect, and the revenue was also of the opinion that it does not affect the substratum of the impugned order. Now, when this matter was heard by Delhi High Court was of the opinion that at this stage, when the writ petition is being heard, it is not open to the department to now contend that external development charges is payment made to a contractor, because the show cause notices were issued on the basis of payment to the contractor. When the orders were passed, nothing was said about that section 194C is not applicable, and the department changed the whole basis of treating the assessee in default and treated the assessee in default by applying section 194I. Now again, the department cannot say that it was a curable defect, and now the matter should be remanded to play the second innings to the department. So Delhi High Court quashed the orders which were passed for treating the assessee in default and said that this is not a case for remand back, because the whole basis of treating the assessee in default is baseless. At the end of this video, once again I am repeating the name of the case. The name of the case is DLF Homes, Panchkula Private Limited versus Joint Commissioner of Income Tax OSD, and this case has been reported in 459 ITR at page number 723. The matter has been decided by Delhi High Court and the date of the judgment is 24th March 2023. Thank you, friends.